Yes.
Well, subject matter, my lord, is closure of a unit of the industry, under Section 25O of the Industrial Disputes Act.
Yes.
There was also in one of the orders, there was direction to qualify the records, Lordship.
Lordship, courts are challenging
A decision taken in review, my lord, by the state appropriate government. This matter has been heard on two occasions.
Records will be required.
Records will be required. One thing, my lord. Second thing, it's a matter which has been heard twice, and both occasions it took more than 3 days.
Lordship, it's a simple.
And there's only one more submission. My lord, 256 employees were affected by this closure. We had taken permission from this honorable court, and we are granted on 3 occasions to proceed with the VRS scheme, because under that scheme they are getting either double or triple the amount which they would get under by way of closure compensation.
Yes.
So out of 256, around only 51 are remaining. The rest have taken the VRS. Yes. Now my instructions are there are about 20 or so who will take the VRS in a couple of days, which is much more beneficial. Now here what is happening is there's one Bombay union who has stepped in. Now they are preventing the closure, and the people taking.
आप कहाँ के हैं? आपकी industry कहाँ है?
We are based, my lord, in Gwalior, Morena.
In Gwalior.
Yes, my lord.
तो आपका जो industry है उसका कोई labor union नहीं है?
There's a union, my lord. They are not objecting to the closure because it's a unit in which, my lord, we used to manufacture bias tires. These are not, now that has to be converted into radial because there's no demand for bias.
Yes.
That is the crux of the thing, my lord. So what we are saying is, my lord, even my friend doesn't have the records today. If the matter can be kept after 2-3 weeks, in that time more people will take the VRS and proceed, my lord.
Yes. What are your objections?
Yes, Lordship. Now, let me simplify this matter for you, Lordship. There's no need for records in this matter. They are simply challenging one order which has stopped the closure of that particular industry.
Yes.
They have taken an interim stay over that particular order.
Yes.
And over that interim stay, since past year, before just taking that interim stay, they closed the industry, Lordship. While the industry closure was not ordered by this honorable court. Thus, the interim stay on the where the closure was being kept aside, they presumed that they should close the industry. And all these 8 years, all these 200 employees they are talking about, they have taken compensation. They have not taken compensation directly after passing the order. Due to all these COVID period happened within these 8 years, 200 employees, what their bread and butter for that, they have to take it. Now, think about those 50 employees who have been fighting since past 8 years. They are still fighting for it because in that particular order, which the closure was granted, Lordship, in that order, there was a second...
Why you are closing the unit?
Well, the 2 kinds of tires are manufactured. One is radial and the other is bias. Now, radial tires is what is being, there's a demand. Bias tires is no demand, 0 demand.
Which tire?
Bias.
Bias.
It's called bias technology. It's a normal tire, nylon tire.
Yes.
Now all vehicles are running on radial tires.
So, the no viability of industry to produce such tires.
Yes, ma'am. There's no demand for it. Only those tires they use bias technology are like.
What
tractor.
are the provisions under ID Act for closure?
Closure, my lord, Section
25O
is what applies, my lord.
Lordship, I would just like to bring your attention at page number 25.
So one by one will come.
Yes.
Industrial establishment to which this chapter applies shall apply for prior permission at least 90 days before the date on which the intended closure is to become effective, to the state government, stating clearly reasons for the intended closure of the undertaking, and a copy of such application shall also be served simultaneously on the representatives of the workmen by registered post with acknowledgement due. Where a notice has been served on the state government by the employer under subsection 1 of section 25FFA, and the period of notice had not expired on the 5th August 1983, such employer shall not close down the undertaking, but shall within a period of 15 days from the said date apply to the state government for permission to close down the undertaking. Where an application for permission has been made under subsection 1 or subsection 2 of the state government, after making such inquiry as it thinks fit, and after giving a reasonable opportunity of being heard to the employer, the workmen and the persons interested in such closure may, having regard to the genuineness and adequacy or the reasons stated by the employer, the interests of the general public and all other relevant factors, by order and for reasons to be recorded in writing, grant or refuse to grant such permission, and a copy of such order shall be communicated to the employer and the workman. When application has been made under subsection 1 or subsection 2, as the case may be, and the state government does not communicate the order granting or refusing to grant permission to the employer within a period of 60 days from the date on which such application is made, the permission applied for shall be deemed to have been granted on the expiration of said period of 60 days. This is a deeming clause, my lord.
Yes.
An order of the state government granting or refusing to grant permission shall, subject to the provisions of subsection 6, be final and binding on all the parties and shall remain in force for 1 year from the date of such order. 6. The state government may either on its own motion or on the application made by the employer or any workman review its order granting or refuse to grant permission under subsection 3 or refer the matter to a tribunal for adjudication. Provided that where a reference has been made to a tribunal under this subsection, it shall pass an award within a period of 30 days from the date of such reference. Number 7, where no application for permission under subsection 1 or subsection 2 is made within the period specified therein, or where the permission for closure has been refused, the closure of the undertaking shall be deemed to be illegal from the date of closure, and the workman shall be entitled to all the benefits under any law for the time being in force, as if the undertaking had not been closed down. Notwithstanding anything contained in the foregoing provisions of this section, the state government may, if it is satisfied that owing to such exceptional circumstances as accident in the undertaking or death of the employer or the like, it is necessary so to do, by order direct that the provisions of subsection 1 shall not apply in relation to such undertaking for such period as may be specified in the order. Number 9, when undertaking is permitted to close down under subsection 3 or where permission for closure is deemed to be granted under subsection 4, every workman who is employed in that undertaking immediately before the
Yes,
date of
now read
application.
the order. Yes, impugn order.
My lord, can I just go through the facts in the case first?
Yes.
My lord? My lord, this is the petitioner company, my lord. They are involved in the manufacture of motor vehicle tires.
Yes.
Now we have two technologies. They are independent. The manufacturing process are independent of each other. Now, those who are working in the bias division are not involved in the radial division. And those who are in the radial, they are not involved in the bias.
Yes.
So we have the bias technology on one hand and we have the radial technology on the other hand. Now, from the month, well, we had we had 256 employees working the bias division.
Yes.
And out of a total of 900 plus employees, the remaining were all in the radial division. From the month of May 2015,
Yes.
the demand for bias tires started drastically dropping. And by September 2015, there was no demand at all.
From September 15.
2015.
Yes.
So production totally ceased in September 2015.
Yes.
And we had to go, seek a closure of this unit in the absence of orders.
Yes.
So an application was moved on 1st of March 2016. Now right from the period,
When you moved application.
1st March 2016,
Yes.
we gave notice, to the state government, the appropriate government,
Yes.
to the workmen also. Notices were served as required under the
Yes.
section, and also to the representative union.
Yes.
That's the respondent number 2.
Yes.
The state government in turn, my lord, transferred the matter to the Labour Commissioner to hold a fact-finding inquiry.
Yes.
On 11/3, my lord, 2016, Commissioner, Labour Commissioner issued notice to all the parties concerned,
Yes.
and the first hearing was scheduled for the 21st of March 2016.
Yes.
On 22nd of March 2016, the Labour Commissioner in turn referred the matter to the Regional Labour Commissioner in Indore,
Yes.
who in turn, my lord, noticed all the parties concerned parties.
Yes.
Now, ALC had a detailed inquiry. Both all the parties were permitted to place the case before the RLC. Based upon the submissions and the material that was brought, the RLC recommended for the closure.
Yes.
On 30/4,
When we
2016,
recommended closure?
for closure, that recommendation was, my lord, I think 22nd of March. 22nd of March, my lord, 2016.
Yes.
On 30th of April 2016,
Yes.
state government granted permission for closure, allowed my application under section 25O, imposing 3 conditions, my lord.
Yes.
On 3rd of March or 3rd of May, this Bombay Union moved an application for review.
Yes.
Their sole contention was this, that we have manufacturing units in other parts of the country. We are in the process of even acquiring other tire manufacturing companies like Birla and etc. So their contention was this, that we transfer orders from other states like Himachal Pradesh and all to Morena for manufacture, and then we can continue the Morena plant.
Yes.
So this was, it's not the case that we were not receiving orders in Morena. There are cases you can get work from other states and
Yes.
keep the factory going. This is their sole contention for review. My lord, if I can now take my lords to the orders.
So what happened in review?
A review was allowed.
Review was allowed.
Allowed.
So go to that order directly.
My lord, before that order, my lord, I'll have to take my lord through all the applications and
So
complete.
we'll see if it is required.
You see, we cannot, my lord, I have to show that whatever that, for an application to be allowed under section 25O, I have to establish that the reasons are genuine and adequate.
So you have told the reasons. Let's see what waked upon the minds of reviewing authority in reviewing that order.
My lord, if I read the order.
So only
25
2 orders. First order is granting you permission to close. Then second is review order.
Granting with 3 conditions, Lordship.
Yes, yes.
There were 3
So
conditions.
read that order and review order.
My lord. My lord, if I can draw my lord's attention first to P1, my lord.
Yes.
That is my part of my application, that's it. And the my lord, is dated 1st March 2016, addressed to the appropriate government. We are enclosing an application seeking closure for an obsolete biased tire manufacturing section based at Banmo district, Morena, MP. We started manufacturing automotive tires in our Banmo tire plant in the year 1991.
What you are reading?
That is Annexure P1, which is my application, part of my
So
application.
not required. See the order and reasoning in it. If required, then we'll come back on this.
We'll come back. My lord, page 20, my lord.
Page 20.
21. That is RLC's report, man.
Yes.
Well, like, just take my friends. No.
कृपया उपरोक्त विषयक संदर्भित पत्र का अवलोकन करें, जिसके माध्यम से जेके टायर इंडस्ट्रीज लिमिटेड बानमोर जिला मुरैना द्वारा औद्योगिक विवाद अधिनियम 1947 की धारा 25O के अंतर्गत बायस टायर उत्पादन इकाई के बंदीकरण की अनुमति संबंधी आवेदन पर जांच कर इस न्यायालय में प्रतिवेदन चाहा है। उक्त के प्रश्न में प्रकरण में प्रारंभिक सुनवाई इस कार्यालय स्तर पर दिनांक 21/3/16 को की गई, जिसमें आवेदक प्रबंधन जेके टायर एंड इंडस्ट्रीज लिमिटेड बानमोर जिला मुरैना और अनावेदक श्रमिक पक्ष की ओर से उक्त औद्योगिक इकाई के दोनों यूनियन जेके टायर बानमोर कामगार संगठन रिप्रेजेंटेटिव यूनियन व एक अन्य यूनियन एसोसिएशन ऑफ केमिकल वर्कर्स जिसका रिप्रेजेंटेटिव यूनियन होना बाबत दावा न्यायालय में लंबित है की ओर से प्रतिनिधि उपस्थित हुए। उक्त द्वारा निम्नानुसार पक्ष प्रस्तुत किया गया। प्रबंधन का पक्ष। प्रबंधन प्रतिनिधियों ने अवगत कराया कि जेके टायर बानमोर की 2 उत्पादन यूनिट हैं, रेडियल और बायस। बायस यूनिट की टेक्नोलॉजी पुरानी हो जाने से बायस टायर का ऑर्डर प्राप्त नहीं हो रहे हैं। सितंबर माह से इस यूनिट में कोई मशीन नहीं चलाई गई है और बगैर कार्य के वर्कर्स को घर बैठे भुगतान करना पड़ रहा है। इस यूनिट में
यस,
256
रिव्यू का ऑर्डर पढ़िए, ऑर्डर ऑफ रिव्यू।
Lordship, before that, the order which was reviewed, that is important, Lordship, which is at P3. They have annexed at P3, Lordship.
Yes,
Kindly, I would like to bring your attention to page number 25, Lordship. The 3 conditions which the closure was being imposed. The first is our point, Lordship. आवेदक प्रबंधन द्वारा बंदीकरण से प्रभावित होने वाले श्रमिकों की सेवाएं लास्ट कम फर्स्ट गो अर्थात जो कि सार्वजनिक कनिष्ठ श्रमिक हैं उनकी सेवा समाप्ति सर्वप्रथम होगी तथा सार्वजनिक वरिष्ठ श्रमिक सबसे बाद में जाएंगे के सिद्धांत का पालन किया जाएगा। फर्स्ट कंडीशन। सेकंड कंडीशन, यदि स्थापना में भविष्य में विस्तार किया जाता है अथवा रेडियल टायर यूनिट या अन्य सेक्शन में श्रमिकों की नियुक्ति की जाती है तो बायस टायर के बंदीकरण से प्रभावित होने वाले श्रमिकों को आवेदक प्रबंधन द्वारा उनकी योग्यता के अनुसार नियुक्ति का प्राथमिकता दी जाएगी, विच दे हैव नॉट गिवन। थर्ड पॉइंट, आवेदक प्रबंधन द्वारा बंदीकरण के प्रभावित होने वाले श्रमिकों को भुगतान किए जाने वाले समस्त अंतिम स्वतों तथा क्षतिपूर्तियों की राशि और इन श्रमिकों के लिए प्रस्तावित वॉलंटरी रिटायरमेंट स्कीम के अंतर्गत प्राप्त होने वाली राशि में से जो भी अधिक लाभकारी होगी वह भुगतान किया जाएगा।
so that they are doing.
That they are doing, but they are paying only 1.5 lakhs, Lordship. The actual compensation is 5 to 6 lakhs as per. But
We don't
coming
have
to
any
the-
complaints from anybody. There's no complaints.
So,
This is the
how-
only
how
union,
will we
Bombay
come-
union.
because-
This is the Bombay union.
Because the matter is pending, and the majority of the employees are with Bombay Union, Lordship. It's not a Bombay Union; it's a national union representative of chemical workers.
So let's see the review order now.
Yes, Lordship.
My lord, page 74.
Page 74,
In my
annexure.
P7. No, no. P8. I'm sorry, Lord.
P8. Yes. Yes, yes.
एसोसिएशन ऑफ केमिकल वर्कर्स मुरैना के सचिव द्वारा दिनांक 3/5/16 को प्रमुख सचिव श्रम मध्य प्रदेश शासन को संबोधित करते हुए एक आवेदन किया गया जिसमें अनुरोध किया गया कि शासन द्वारा जेके टायर एंड इंडस्ट्रीज लिमिटेड के प्रबंधन की ओर से औद्योगिक विवाद अधिनियम 1947 की धारा 25O के तहत बायस टायर यूनिट के बंदीकरण हेतु प्रस्तुत आवेदन को अनुमति दिए जाने संबंधी शासन के समसंख्यक आदेश दिनांक 30 अप्रैल 2016 का वे पुनर्वलोकन चाहते हैं। पुनर्वलोकन हेतु मुख्य रूप से निम्न आधार को कमजोर करने के उद्देश्य से बायस टायर सेक्शन को बगैर पूर्व अनुमति के दिनांक 22/10/15 को ही बंद करा दिया गया, जिससे लगभग 500 स्थायी श्रमिक एवं अन्य की कामबंदी कर दी गई। इससे प्रभावित होने वाले अधिकांश श्रमिक प्रार्थी संघ के सदस्य हैं। प्रबंधन द्वारा बायस टायर की मांग में कमी संबंधी एवं वित्तीय विवरण संबंधी गलत तथ्य प्रस्तुत कर आदेश प्राप्त किए गए। प्रार्थी संघ को
Yes, what do you want? Respondent.
Lordship, we majorly want that the remaining employees, they should be reinstated. And as per the
Where?
order, at the same unit, Lordship, the unit is working.
No, no. Unit is working in respect of radial tires, but not in respect of bias.
Lordship, there might be hardly a small 1 or 2 weeks training, and they are already working the tire unit itself. Why the
So whether there are vacancies, whether they require them.
Lordship, they have given jobs to the newly workers which were not regular, and they have removed them. While the order was clear that first they should be given
No,
the
so how
opportunity.
many workers were given job?
Lordship, more than 100 workers have been employed.
So you have filed any documents? Any
Lordship, but as per the order, if the
we
honorable court
cannot
order,
force a factory to continue a factory when there is no viability of it.
Lordship, fine, but
Because,
the major contention is if the factory is
Now
being
it is a capital driven market.
Yes, Lordship.
If they do not want to continue their factory, they may stop it. They may give compensation. That's all.
Then, Lordship, the compensation is the right amount, calculating the full gratuity also, and also the retrenchment amount also.
So the affected party may come. आप कैसे कह रहे हैं कि right amount has not been given? After from 256, they say 250 has already accepted.
200 employees.
कितना दे रहे हैं आप compensation?
My lord,
In
depending
accordance
upon,
with act दे रहे हैं.
in accord, no, my lord, we've gone beyond that. If I go
In
by,
accordance with law, you are paying them.
Yes.
कम तो नहीं दे रहे हैं.
my lord, we're giving 3 times what we are liable
What
to
else
pay.
is required?
Lordship, we
My
are
lords have
requiring-
taken note of this.
We are requiring that as per the
By
condition.
whether
2
they are violating any law in giving compensation amount, you point that out. If there is any violation or infraction, then court will intervene. Otherwise, not.
Lordship, the court should intervene at the second point because they are not allowing these people to work because they are having vacancies right now. People are applying.
So
for
on
the
what
jobs.
basis you are saying?
Lordship, I also have one of the.
So oral arguments will not
I
be
agree with you,
considered.
Lordship.
Yes.
There was an advertisement for the radial tire employment scheme.
Where is that?
Specifically held that we cannot be compelled to go beyond the terms of the statute. Now, terms of the statute means only 15 days wages per every year of service. What we have done is, my lord, we've taken out that details and we're giving them twice to 3 times this thing, so there's not a complaint from a single employee.
Lordship, rather than the secretary of the
Terms of the statute. Now, terms of the statute means only 15 days wages per every year of service. What we have done is, my lord, we've specifically held that we cannot be in Gordon Woodruff, my lords have specifically held that we cannot be compelled to go beyond the terms of the statute. Now, terms of the statute means only 15 days wages per every year of service. What we have done is, my lord, we've taken out that details and we're giving them twice to 3 times this thing, so there's not a complaint from a single employee.
Lordship, rather than the secretary of the current union is also present over here. He's representing all the employees. He's also one of the employees over here. He is clearly stating.
Where is he? आ जाइए. आपने तो कोई डॉक्यूमेंट नहीं फाइल किए हैं. They are making employment of other laborers in radial tire factory. या वहाँ पे वैकेंसी है.
दिया है ना बेनिफिट
Yes.
सात वालों को यहाँ से
कहाँ डॉक्यूमेंट कहाँ फाइल किए हैं आपने? Without documents you cannot argue.
सब डॉक्यूमेंट
Unless and until you give some evidence.
हम लोग को दिया है वो
His spontaneous answer was no. That was a spontaneous answer, and that is always the truth.
अंदर से जो लड़के थे कच्चे हम लोग को सबको प्रमाण करिए हमको निकाले सर
The employees who are not regular, they have all made regular. जो इनसे पुराने employees, जिनके बाद जिनको भर्ती हुई उन लोगों को बाद में इन्होंने regular कर दिया. रेडियल टायर में डाल। What they are demanding कि हमें आप ट्रेनिंग दे दें एक
तो
दो हफ्ते
जितनों
की।
को एडजस्ट कर सकते थे करेंगे, सबको थोड़ी ना कर लेंगे।
किसी को भी नहीं किया ना लॉर्डशिप बटन ने, सबको
अभी तो आप बोल रहे हैं कि कर लिया, रेगुलर कर दिया कुछ
जो
लोगों को।
रेडियल टायर में जो थे यंग जो लड़के आए थे,
Whether you have made a, if no pleadings, then I will not consider oral arguments.
it's at the rejoinder we have filed lordship.
Rejoinder you have
No,
filed?
no, can't be rejoined.
No, lordship, reply on the behalf of respondent number 3.
Yes. And under what provision this power of review was excised?
Well, that is there under section 25O subsection 6.
25 subsection 6.
6. The state government may either on its own motion, subsection 6,
Yes.
or the application made by the employer or any workman, review its order granted or refusing to grant permission under subsection 3 or refer the matter to a tribunal for adjudication. Provided that where reference has been made to a tribunal under this subsection, it shall pass an award within a period of 30 days. No, this was the
So
provision
there
which
is no
has.
pleading. Petitioner has filed this petition under Article 226 of the Constitution of India, challenging order dated 24/6/16 by which state government has reviewed the order of closure passed under section 25O and has set aside the order dated 3/5/16.
Thirty-four, 2016, Manoj.
It
It's
is?
the 30th of April, 2016.
30th of April
16 was
2016.
granted permission for
Full
closure.
stop. Application filed by petitioner for closure of unit was allowed on ground that company is manufacturing two type of tires, radial and bias. Technology of bias was old and there was no demand for bias tires after May 2015, and after September and in year 2016 production of bias tires stopped and factory management was making payment to laborers without there being any work. Full stop. A review application was filed before state government, which was entertained on grounds permission for closure was granted on fulfilling three conditions, which is reproduced application for review. That is page number
Page number 72.
70.
The application is at page number 28, Manoj.
28.
That is annexure.
P4.
Application for review. No, where is order of
The order is P8,
Order is
my lord,
P8.
dated 24/5/2016. That's
order for review?
Order starts from page number 74, lordship.
Page 74.
Starts from the same page. From the bottom.
In review, Principal Secretary, Government of MP, Labor Department held that applicant नो, ये तो आपका 16 का ऑर्डर तो गवर्नमेंट का है.
Page number 74.
Yes.
It's dated 24/5/2016. This is the order that has been passed in review by the Principal Secretary, Labor Department.
Where is order of review?
This is
74.
Yes,
क्या क्या लिखा है? ये जो conditions हैं that is mentioned in page number 72 है, which is reproduced as under. Review application was allowed on grounds that other plants are continuing manufacturing of bias tires, and orders which are received in said factories may be transferred to factory at Morena
Yes, my lord.
for production of tires. Other companies like Apollo C8 Birla are also continuing production of bias tires, which shows that demand for bias, there is demand for bias tire in the market. Full stop. No, while granting permission for closure, market survey regarding production and sale was not carried out. And further, closure of unit will have adverse impact upon laborers. On said grounds, order was reviewed. Full stop. Learned senior counsel appearing for petitioner submitted that an error has been committed in reviewing the order dated so and so. इसमें ऊपर ये भी लिख दें लास्ट कम फर्स्ट को जो कंडीशंस हैं in reviewing the order, full stop, company was not viable as there was no production, full stop. Production of bias tires, no error has been committed in granting permission for closure, full stop. Counsel appearing for respondent union submitted that conditions were imposed upon the factory on which closure is permitted. Said conditions were not followed. New employees were engaged by the factory in radial division, but employees of bias, but employees of division bias was not adjusted. Full stop. It is submitted that appropriate compensation is also not being awarded to the laborers. Yes, state आपको कुछ कहना है?
We are relying on the grounds which have been given for allowing the review on page number 70.
Government advocate appearing for state supported the order passed by the reviewing authority. Full stop. Heard the counsel for the parties. Full stop. Reviewing authority has committed an error in comparing petitioner factory with other factories who are engaged in production of, who are continuing in production of bias tire. Viability of factory of petitioner's factory is to be examined. Petitioner factory has specifically stated that factory is not viable. Full stop. There was no demand for the tires of factory, and they have to close production. Nothing has been brought on record by respondents that production of bias tires was not closed after 2016. Full stop. In view of same, by comparing petitioner company with other factories situated in other parts of India, reviewing authority has committed an error in interfering with the order of closure, full stop. It is also informed at court that laborers are being paid what
Being a VRS
When-
which is double to 3 times the
are
compensation.
are being paid VRS, which is double or three
Double
times.
or 3 times, depending upon the period of labor and services rendered.
क्या लिखा है? Company is also paying VRS to the laborers, which is more than the statutory compensation prescribed under section 25O, full stop. Considering aforesaid circumstances, petition is allowed, order dated so and so is quashed.
Ashok, there's a humble submission
yeah.
that the point 2 of that particular order may kindly be made in this order itself,
Yes.
that if the employees are applying there,
Yes.
they kindly be granted job if the job is available.
It goes without saying
Yeah,
that
that we are already doing, my lord.
No, Lord.
No.
if any advertisement is issued in radial division for
Yes, Lord.
for employment of laborers, then laborers of biased tire may be given preference.
Who are being retrenched by this.
My lords,
Yes,
state government order dated 30th April 2016 will be restored, my lord. That is the permission for closure.
so it goes then that order will come in force automatically.
Just for clarity, my lord, so that we don't have further litigation.
Order dated so and so
30th April
is
to
bring into operation.
oblige, my
And
lord.
that condition may kindly be.
Uh,
We are complying with all 3 conditions. We're not
Ashok,
challenged it, my lord.
if it may be kindly mentioned in the order, that would be.
if if petitioner factory issues an advertisement for employment of laborers in radial division, then laborer who has been retrenched from bias division may be
given
accommodated
priority.
Obliged.
and given preference
Highly obliged.
if they have requisite
But
qualifications.
these conditions, my lord, I successfully challenged in another case. All 3 conditions were removed. But
Were
yeah, we are,
removed?
yes, my lord. So I won't say that, my lord, I'll stick
So
with
if it has been removed, then why?
No, not in this case, in another case, my lord, hence in text case. My lord, squash these conditions.
Highly obliged.
Obliged.